and remove this background. Yes, thank you. Welcome, everybody. It's good to have you all here. Okay, my name is Bhaskar. I am with Free Press Journal. I also teach at various institutes, including NMIMS as a guest faculty. And the other gentleman who you can see on the screen is Dr. Paritosh Basu, who is Senior Professor and Chairperson of MBA Law at the NMIMS School of Business Management. He's engaged in several research and consulting activities. Since the topic that I'm going to discuss has a lot to do with law, I thought it would be very, very prudent to have an expert on law to be with us. So while the first 20 minutes, I will talk about what the entire process is about. After that, he and I will engage in a discussion and we'll talk about what the possibilities are before India. Okay. Before I begin my presentation, there are 2 or 3 things that I'd like to mention. First, although my presentation has about 16 slides, I'll try to finish them in 20 minutes, which means less than 1 minute per slide. If you want PDF copies, you can ask Free Press Journal or Narsim Munji to send you the copies. You'll get PDF copies of the presentation, so you don't have to make notes about anything that I have written. Whatever is not there on the slides, you can give me, you are free to make notes. And if you want a longer version of the lecture on dispute resolution, I'll be taking this lecture once again on the 28th. You'll get the invitations, you'll get the links, you can log in for that lecture, which is a more exhaustive one. Before I begin, let me go on to the presentation and share the presentation with you. Here we are. I deliberately chose the topic dispute about dispute resolution because nobody in India is quite clear how one should resolve disputes, because a very interested party in all disputes is the government of India. And while I will go ahead rapidly, at the background you must remember that law is a very serious subject. It is the last bulwark that you have against any kind of oppression, against any kind of legitimate change you want in a society. It is the only way you can protect the legitimate and prevent the illegitimate. And if these objectives are not met, then of course you have a problem, because then the legal system can come to a grinding halt. It's like putting sand in a machinery. When that is not done, the cost of doing business soars. The Romans knew it. In almost 100 BC, you'll find them in Pliny's records that the Roman Senate is agitated that it takes too long to resolve disputes, and that has pushed up the cost of doing business. India is oblivious of the cost of doing business because half the disputes are by the government and the taxpayer pays for it, the government does not. Alternative adjudication processes are required urgently. You need to resolve disputes quickly. And criminalization of politics and politics learn to coexist if the rule of law breaks down. 25 years ago, when my hair was still black, at that time, I had visited a dinner party of a very senior diplomat. And there I met his German film producer, a documentary producer. And 25 years ago, he warned me that, remember, in a country like India, where illiteracy rates are high and poverty is rampant, you quickly need to make institutions stronger or pull the people up from poverty and illiteracy into literacy and economic well-being. If the 3 don't happen, most important institutions are not strengthened, the next step is organized crime Because organized crime is very attractive for the people who are marginalized, for the people who are weak. To make you understand that, let's go to a situation where, let's assume that you were staying in a slum. And let's assume that your sister, your daughter, your wife were being catcalled on, and at the same time, someone was threatening to molest them. They come and complain to you. Remember, you're in a slum. So what would the natural reaction be? You first go out and try to tell them, hey, don't do this. If they are abrasive enough and ignore your warnings, what do you do? Do you go to the police station or do you go to the local dada? The answer is simple. You go to the local dada because you get speedier dispute resolution. Now, what has happened suddenly? The police station, the courts have become irrelevant. The illegitimate has become relevant. What is even sad is that the people you pay taxes to protect yourself do not protect you. And the mafia is better because when you pay for protection, you actually get protected. That is a time when the country is at the verge of a total collapse of law and order, and organized crime begins to become more and more relevant. Organized crime is a very funny thing. It does not touch the women in the locality. It makes its money from gambling, prostitution, real estate. But the local dada does not touch the girls in his area because he has to protect that parish. So when someone tries to molest my daughter, he goes and beats them up a couple of times. They file a case. He files a counter case. He has a criminal record. And the day he stands for election, I will vote for him because he is my protector. Behind every criminal politician, you'll find a constituency that he protects. And crime and politics become inseparable because you have not been able to deliver justice quickly enough, making me, the slum dweller, go to the illegitimate, the illegal, which is more relevant for me. That is why it's important to have speedy resolution of disputes. And this is more important when it comes to business. And when it comes to business, there's a very interesting case which changed India's outlook towards a dispute resolution. In 1989, a company, I'm going to skip this, skim through this. You have copies of the PDF afterwards. But just to tell you the story in a nutshell, in 1989, an Australian company, White Industries, came to India, had a collaboration with Coal India to do some business. There were disputes, and it wanted to break the contract according to the norms that had been outlined in the agreement. Coal India did not agree. So he went to the UK and went into arbitration and got a damage against Coal India. Coal India immediately went with that case and went to the Calcutta High Court and immediately got a stay order against execution of the damage award. The reason? There's a small clause in the arbitration clauses which allows the government to intervene when it is against national policy, when it is against sovereignty. Now, because Coal India was owned by the government, they said, we are the government. This is sovereignty. And they went to Calcutta. White Industries went to Supreme Court and said, please stop this nonsense and ask Calcutta to vacate that stay. Supreme Court said, yes, but you see, we have an earlier ruling by a 3-member bench saying that this can be opened in the case of government companies. So White Industries said, change the law. Nothing happened. So they waited. And then after some time when nothing was happening, White Industries went to Singapore and using the bilateral investment treaty, which India had with Australia, told the Singapore courts that my damage amount would have been my investment, and my investment is being stopped by the government of India. And the Singapore government ruled against the government and levied a huge penalty on the government, not on Coal India. That started the ball rolling. There were urgent meetings in the government, and immediately a 5-member constitution bench was set up by the Supreme Court, and the 5-member constitution bench then gave a ruling the next day in 2012, remember, 1989 to 2012. And the 2012 judgment of the Supreme Court, and the references to the Supreme Court judgment are given in the PowerPoint slide, was that whenever a decision is taken by an arbitration body with a seat outside India, Indian courts cannot reopen that award. By implication, whenever an arbitration award is decided upon and an award is given within India, it can be reopened by Indian courts. So naturally enough, everybody started seeking arbitration in a seat outside India. By 2014, the government said, no, this will not do. We can't have outside courts deciding what India should do. And they decided to cancel all the bilateral investment treaties that India could with countries, and 56 treaties were cancelled. And the government put up a model arbitration code saying that no company shall go in for international arbitration unless they have exhausted existing legal avenues within India. Now, everybody knows that once it comes to Indian courts, the case can go on for 10 years, 20 years, 30 years. And that in turn brought a screeching halt to major investments from overseas into India. There were exceptions, but these exceptions were exceptions. It could have been 10 times more, 20 times more, 100 times more. India was a large market. India was seductive. But India had this one problem, that disputes could not be resolved quickly. And as a result, when 2014, the government brought in a rule saying that you cannot have these BITs. And I said that today, 69 out of the 84 BITs have been terminated on various dates. BITs are normally valid for 10 to 15 years. Some of those BITs survive because their expiry date is not over yet. One of the most important countries with whom we have a BIT, not directly but indirectly, is Singapore. And that is why many disputes are still sent to Singapore for adjudication. When the new BIT law was brought in, one of the first countries to sign the new BIT law, which says that you will not go for international arbitration without exhausting existing legal avenues in India, was Cambodia. But Cambodia's name does not come in the list at the moment. I do not know why, but Cambodia was one of the first signatories. And we have hardly any business with Cambodia. So the signing was meaningless. Thereafter, 2 other countries signed, Belarus and Brazil. We have some business with Brazil, but hardly any with Belarus. And almost every other country has refused to sign the new model BIT that the government wanted people to sign. Now, when you want to do business and there is no legal redress possible in an international court of arbitration, there's a potential for a new business to emerge, and that is called the political risk insurance. Personally, if you ask me, PRI has a great business potential in India. However, most PRI agreements must require a domestic insurance company. The biggest insurance companies in India are still government owned. As a result, PRI hasn't taken off as well as it ought to have been. In the meantime, There were 4 or 5 cases, actually 7, but I'm talking about 4 cases in detail. There were 4 cases that were very serious cases. One was the Ranbaxy Daiichi. They went for international arbitration. The arbitration said that the Ranbaxy brothers were wrong, and they asked the brothers to pay a certain sum. They've tried every trick to postpone payment. I don't think the payment has still been made because they're finding some excuse or the other. They've created third-party interest. And till today, that battle continues, and the Japanese are quite upset about this. The other case that was very, very famous was the Tata Docomo. Docomo agreed to invest in Tata Telecommunications, Tata Teleservices. And underlying that investment was a very secret document, which said that in so many years' time, if we want, we can take back our investment, and Tata Teleservices or its nominee or a third party will buy back our shares at this price, giving them a decent rate of return for those years. So it is a market price or a minimum fixed price. That was the agreement behind it. And this creates another problem. Initially, the Tata said that the government of India will not allow this, rightly so, because this is a debt instrument. It's like mortgaging a share. An equity investment is different from a debt instrument. But when an equity investment is made with a hidden agreement which says that you're going to get a fixed rate of return, it is an issue that I don't think has been resolved till now. And many major equity investments will continue being made with an underlying guarantee buyback agreement, which is not strictly an investment decision. Anyway, Tata Docomo paid up. The matter was resolved. We had another case. Devas Multimedia. It had bought some bandwidth from Antrix. The papers were sent to the government. The government cleared the proposal. They said, okay, we are paying 300 million to ISRO through Antrix, which is a subsidiary of ISRO, Indian Space Research Organization, for sending up a satellite in the sky, because Devas wanted a band known as S-band that India did not use. The agreement was signed, the first tranche of money was paid, and then came the 2G scam. And the Supreme Court said any tender that has any order, any contract that is signed without inviting tenders is null and void. The government panicked and cancelled Devas Multimedia's contract. Now, Devas Multimedia was using a technology that nobody knew about. It was not a marketable product. An auction makes sense if there's something to be marketed. This was according to the rules that were prevalent in that time. At that time, it was cleared by the government, and Devas was quite upset that its agreement had been cancelled because it had ongoing contracts, which also had to be reversed and cancelled. So Devas went for international arbitration. There was an award against the government of India. The government challenged the award, went to a high level. The government lost even that. And having lost that, the government decided to file criminal charges against Devas's promoters, saying that now because it's a criminal case, we do not want to give effect to the International Tribunal Award till these criminal cases are decided. And the matter is a very vexatious case today. Then, of course, you had the Vodafone bombshell. The government changed the rules of taxation. If you remember, and that's come in the papers lately, if you remember, the Vodafone challenged the income tax rules. It went to the Supreme Court. Supreme Court ruled in favor of Vodafone, and the government decided to change the rules retrospectively. Vodafone's parent went to the International Arbitration Council and finally got an award that the government's decision was wrong. Retrospective laws is like harming investment. It changes the rules of business. Then, of course, there are other cases, Nissan, the Korean case, and Vedanta. Vedanta case is yet to be decided. Now that we have this kind of a situation, we have to arrive at an understanding of what the country has to do in the face of these disputes that are there. Many countries have said we will not invest into India until and unless India has some method of dispute resolution. India suggested that we'll have an arbitration center in India. Great idea, but it is within India. It goes against the Supreme Court judgment of 2012 that anything that is decided in India can be reopened by Indian courts, which means that the Supreme Court judgment may have to be reversed or modified, or international arbitration should be allowed. At the moment, only those countries which have a BIT still pending, bilateral investment treaty still pending, are in a favorable position. The government has tried to persuade those countries, including Singapore, whether they could terminate the BIT. All the countries have refused to allow termination. Sooner or later, the BITs will end. Will that stop investments into India? Will that bring almost all investments to a screeching halt? Even the little that's coming in right now through the windows of Singapore, will that also stop? Nobody knows. But this is a decision India has to take, because India will need money quickly, because its GDP has fallen, its economy is in a shamble, it needs the money, but money needs guarantees. Money which comes into a disputed territory is often risk money at very high risk premiums. It pushes up the cost of business, just as the Romans had said it would once upon a time. I'll just skip to the next 2 or 3 slides so that Paritosh Basu does not get annoyed with me. One of the reasons why judicial processes are very slow is because India has not filled up all the vacancies in the courts quickly enough. This is an old chart, but if you notice, in all categories of judicial offices, 30% of the vacancies continue to linger on, which means that you're not even using the existing capacity properly. You want the cases to be delayed, because a delayed case allows you to tinker around with evidence, with a lot of other things. A delayed justice only strengthens the oppressor's hands. It weakens the oppressed. And the government does it in 2 ways. One of the reasons why the government, over the last 7 decades, it's not this government alone, it's an accumulation of 7 decades of history, is because in 1969, Indira Gandhi decided that the legislature should have the right to change laws. So she tried to ram through a legislation on the privy purses. I've written why about the privy purses in my book, which I was there right in the first slide, where I have a whole chapter on dispute resolution. And when Indira Gandhi lost that case in the Supreme Court, after the Bangladesh war, she reconstituted the Supreme Court bench. It heard the case again, and the privy cases was abolished. That case was important because it was a constitutional promise India had made to the princes who had agreed to join India. It was thus legalized, but what has been legalized is not always ethical. After that, legislators believe that they have a right to change the laws whenever they want. And this is a dangerous thought. And the politicians do it by 2 ways. One is by the numerical majority that they may have in parliament, and the second is by building vote banks. For example, just briefly, here is a way in which almost every political party, functions. Look at the average population growth, 17%. Look at the growth of slums, 25%. People say the slums have won because people look for jobs, but I'm also looking for jobs. I'll go to Ajmer if there's a job available there, and the Ajmer person will come to Bombay if there's a job available here. There's a migration of non-slum people as well as slum people. Why did slum populations grow faster? Someone was encouraging them. And then if you look at households in slums, they grew even faster at 37%. Why? Because all entitlements by the government are to households. Free electricity, for each household, this much of ration for each household, this gas cylinder for each household. So if you and I are brothers and sisters, we break ourselves up into many households. And greed is so much that each person belongs to 2 households, which is evident in the next figure from the census, which shows that unlike the average size of a household of 5 people, in the slums it is only 0.5 people. 1 person belonging to 2 households. As a result, a slum gets 10 times the entitlements that it was supposed to get. More important, the politician gets a vote bank and he outvotes the existing population because he's got his people to elect a person who belongs to the politician's cadre. This is a threat to democracy. It's a threat to even dispute resolution, and dispute resolution begins from here. Solutions are needed. Maybe a special court, maybe more courts. And let's talk about acts of God or the parliament is supreme, because eventually the constitution is supreme and the courts are supreme. This is something the government needs to understand. Here's a bit of extra reading material, and these are the other topics that we'll be talking about shortly. Okay, I will end my talk here, and let me see if I can end the screen share. That finishes my discussion. And Dr. Basu, help. Tell me what we should do. How should India resolve this problem of a vexatious situation of little dispute resolution?
Thank you, Mr. Bhaskar, for setting the context of the discussion, not only for balance minutes of this particular session and going forward the panel discussion session. So if I may take liberty to bombard you with some questions.
Which I thought I was going to ask you questions.
which will perhaps bring out some of the issues which India may think of going forward.
Yes, sir.
My very first question is that, okay, when there is money, where there is commercial people, where there is agreement, there will be dispute. We will not be able to avoid it.
Yes.
But where do you think the disputes over dispute resolution lie? Where is the place? Where does it lie? Do you think the whole fundamental issue is the process which should be transparent, and that a transparent process should be followed between the 2 or 3 parties in an agreement, right from that stage to the award stage and implementation of award stage? Or do you think that Indian ecosystem has a mindset of litigation and litigating and consider post-arbitration award one more step to go to the court and delay my process of payment if I am in a losing end? Is it the issue? Or it could be that do we need to change the approach to the alternate dispute resolution process, because our mindset is still that the retired court judges are the best arbitrators. We do not have any shortage of manpower or shortage of jurists in India and subject matter experts who can definitely sit at members of the tribunals and give a more acceptable judgment, which should be transparent, process-oriented, and implementable by both the parties. At least you convince me or I convince you, but the process of convincing should continue in a transparent manner.
Dr. Basu, all the answers are there in your questions. First, okay, but let me elaborate. There are 2 issues involved. One is an anecdote that I picked up in Singapore. It's a true story. A friend's wife was doing certain business. She used to get things from India as samples before Diwali, before Rakhi, before any festive occasion, because the Indian diaspora is large. And she would take the samples to each superstore and say, look, I can bring this to you at this price. She would do a markups, etc. and say, give the quote the price. The superstores, if they like the product and they like the pricing, they would say, yes, we want so many quantities, and they give the advance and the money and the goods would come in. One day, after several years of business, one superstore said, I am not going to pay you the balance amount. And she said, why? because you gave it to me at this price, you gave it to my other shop at that price. The girl said, listen, we have got a contract. I may have signed with him on another date when the prices were different to the market, because mine is back to back. Maybe the quality was different. Irrespective, there's a contract, please honor it. The man said, I'm not going to pay. Do what you want. Now, he was a Singaporean, she was an Indian. She went back home and kept quiet. Till one night, there was an argument with a husband and wife, and she was scolding the husband. The husband said, stop scolding me, go scold that shopkeeper. You keep quiet when there's a shopkeeper involved. That girl got very upset. That night, in her anger, she wrote out a postcard, a small letter to the Ministry of Justice saying that this is what has happened, and sent it out. Within 4 days, she gets a summons to the court. 4 days. Please bring all the documents with you. In Singapore, if there's a summons, you don't disobey the summons. She goes, she's petrified. She sees the judge there. The shopkeeper there, the superstore owner there, and he looks at her very angrily. At the right time, both are called by the judge's clerk. The clerk checks out this document, this document, all the documents, so that the judge does not have to look for the documents. All the documents are there. Afterwards, in 10 minutes, the judge calls both of them. And the judge just asks one question, Mr. So-and-so, do you have a contract? He said, yes, but. I didn't ask, but do you have a contract? So he said, yes. Told the girl, do you agree there's a contract? The girl said, yes. Is there a price mentioned there? Both said, yes. Is there any clause which says that you will not pay? No, sir, but. I don't want but. I want to know whether there's a clause in that agreement. Show me the clause. There's no clause. Mr. Shopkeeper, you're wrong. You will make the payment of this at this rate of interest plus a penalty of so much. You'll pay the court this penalty for making it do this extra work for you. And you can go out and work out the terms of settlement with my clerk in what installments you're going to pay. And the matter must be resolved and the payments is made in 1 month. The girl thanked him and she was going out. She said, madam, come back. The girl came back. She said, yes, sir. He said, why have you complained 6 months after the incident? She said, no, sir. He said, please remember, if there's a crime, complain immediately. Don't make a mockery of a judicial system. You think evidence can stay alive for 6 months? The operative line is respect for evidence. If you don't respect evidence, you will not respect justice.
Absolutely.
Allow evidence to die, you will not have justice. What method you follow doesn't matter, but work out a system that you can arrive at judicial resolution within a year for commercial disputes which are a little more complex, and simple cases should be decided in 15 days, 1 month. So what does India do? It reduces the judges. Look at consumer courts. They were supposed to decide a case in 90 days. Now it takes 10 years. We slow down so that we can control the outcome of the judicial process. That is wrong. Does that answer your question?
Okay, I'll come to this in a much bigger way through a different question. I think we'll have to work on it. But I was keenly watching when you were talking about the past cases, and a point came to my mind that perhaps the Indian Jugaad mindset,
yes,
for underpassing, bypassing, overpassing the law, or maybe subtle interpretation of the law through far-stretched imagination and far-stretched arguments, we break the law and finally we delay the process, or we do not accept the resolution which is given. Do you think that this Jugaad mindset, instead of respecting the law and respecting the mindset, is one of the biggest hurdles in the process of dispute resolution?
Yes, but I put the blame on the judicial process. There are two issues you must remember. One, look at the average Keralite, the Malayali. In his own state, he'll go on strike. But once he goes to Dubai, he's the best worker that the country finds. The man is the same, The work is the same, but his approach to work has changed. Why? Because the processes are different. You have the right policy, you have the right processes, even jugaad will disappear. The second point, if there's a jugaad attempt, even for delay, a judge, a lawyer asks for postponement. Make a law that you can't take more than 2 postponements. That after that, you will be penalized or the decision will be taken ex parte. You can pass the laws. The legislative body is within its competence to pass such laws. The question is, will it or will it not? Even till yesterday, the government was thinking of challenging the Vodafone case. Fortunately, as today's papers say, the Attorney General has advised the government not to challenge it. Because every time the government has challenged an international arbitration, it has lost once again, and it has got the international community more upset with India.
Okay, let me bring then put these 2 points together and let us talk about something in a little different direction.
Yes, sir.
Let's say that every single business transaction between 2 parties, wherever done in the world, will be unique.
Yes, sir.
The parties may be different. No single commercial transaction is unique. So every single transaction and every single dispute out of this transaction has to be settled in the merit of the transaction.
Granted.
For the merits of the cases. In such a situation, there is a very huge requirement of a stringent and comprehensive civil law, which is passed by the parliament. But as you know, Indian system is also following common law practices. And wherever there is common law, we have scopes of bringing in various previous instances and prior judgments which may not be correctly and equally applicable to a unique transaction. But because there is some scope of bringing in a common law, we bring that common law, prove that our own civil law is not stringent and comprehensive. In the process, we stretch our imagination and justification and give a solution which perhaps is not acceptable to the aggrieved party. Do you think our law of 1996 Arbitration Act should be made more comprehensive, more stringent?
The law as it exists, even the 1996 arbitration law, can work if you don't allow a Supreme Court or a High Court to reopen an arbitration award. The second you allow a court to intervene and reopen an arbitration award, you are prolonging. Somewhere the buck must stop. In commercial disputes, right or wrong, I can write on my losses, but don't keep me hanging for 15 years. I've lost my money. I can write off the losses and start, okay, gaya. I can start my business ahead. But by keeping me on for 6 months, after 6 months, after 6 months, and I pay lawyers' fees, you break me physically, emotionally, and commercially. So only the fittest survive. A Vodafone can stay alive for 20 years with a case.
Because of their deep pocket, they could fight it out against mighty government.
Correct. Which is how India has specialized in breaking the vulnerable and making the powerful even more powerful. And the most powerful is the government.
You see, Mr. Bhaskar, that because both of us are not lawyers, and from the common man's perspective and understanding, we are trying to see through the windows of law and trying to understand what is what, where the disputes lie over dispute resolution. Let us come to the Vodafone case. Do you think that we as Indians have learned our lesson, and in future we should not be having any hesitation to commit with all conviction, sincerity, and responsibility and respect to laws and our overseas partners that, hey, we will not change our law anymore with retrospective effect. Wherever we lose, we respect the award. Maybe we will change it with prospective effect, not retrospective effect. Do you think that case has given us that kind of a mindset?
No, it has not. Vodafone won because it has still been covered by the BIT. Once the BIT is not there, Vodafone would not have won the case. Once the BIT expires, a case like Vodafone may not get decided. Point one. Point two, just look at last fortnight. A parliamentary promise to other states on respect in GST was sought to be abrogated under the grounds that the pandemic was an act of God and hence the previous agreements are null and void. Which is why the states are going to the Supreme Court asking for an agreement to be ratified, to be treated as sacrosanct and not abrogated. So we've not forgotten the arrogance of changing laws is still there. We need to understand law is law. Somewhere it has to stop. The government cannot pass a law which tries to nullify a previous law. Let me give you another.
Okay.
Okay.
Yeah.
No, go ahead.
Let me come back to.
We'll take one more question and then throw over the Q&A to the audience because we have to finish. Yeah. We have to finish at 3:40, 3:55. At 4:50.
Okay. We have just one last question. There is a train being seen. I was talking to quite a lot of my lawyer friends, and there is a train being seen that whenever there is an international agreement where one party is an international party, Indian corporates are bringing in 2 seats of arbitration. One is at Singapore and one is at London. These are the 2 international forums which they are preferring. And in the process, they are trying to avoid Indian arbitration process. Do you think it's a good trend? Do you think that the Mumbai seat, that is the Mumbai International Arbitration Center, should be made more vibrant, more efficient, more effective by bringing more international jurists and subject matter experts so that Indian systems deserves and brings and calls for respect and finally starts getting respected so that all Indian disputes gets resolved in India only?
I agree. It's most desirable that each country has its own judicial process. Agree. If you want that,
I'm talking about arbitration.
Yeah, I'm just coming. I'm coming. The arbitration center, which is sought to be set up, which is set up in India, in Bombay. One law is missing, that the awards by this arbitration court will not be reopened by Indian courts. That one law is not there.
That is where the Arbitration Act has to be more stringent and comprehensive, and very exceptional few cases can be allowed to be reopened in the court of law.
Precisely. That is where the Supreme Court has to take an amendment on its 2012 judgment and say all Indian arbitration courts will also enjoy the same privilege of not being reopened by Indian courts unless ratified by the Supreme Court. So you take the power away from the government and put the power back into courts. Your voice has gone.
My last suggestion here, that wherever you are dealing with a commercial dispute, which involves a lot of commercial aspects like the technical aspects of any Vodafone case, etc., not only law or Income Tax Act, there you should be taking technical experts. Yes. You can really understand the transactions and the issues of the transactions before the arms of law sets in.
I agree. Totally. Can we take questions from the audience?
Yeah, please. Let's go ahead.
We have a colleague, Mansi, who's there. She's got all the questions from the audience. Mansi, can you come in and tell us what the questions are? Select some because we can take 2 or 3 or 4 questions.
Yeah. Among the interesting ones that we received, one of them was how important investments are when it comes to India's GDP growth.
India investments are critically important. India does not have the money. Its GDP is plummeted. It's what is known as gross capital formation has been declining year after year. Gross capital formation is critical because it means investments made into new capacities for creating new jobs. A recent McKinsey report showed that 90 million jobs need to be created How will you create the jobs without new companies coming up? How will companies come up without investments? Your Indian businessmen are not confident about the business climate. You want foreign money, but then you protect the investments. That is it. Please.
Okay, and yeah, we can take, I think, only one more now. So the next one is, why are Indian arbitration centers not taking off?
Simple rule, which Dr. Basu and I have just discussed. Unless and until we can put in a termination point to disputes, that beyond this, it cannot be reopened by Indian courts. It will not take off in India, which is why all major arbitration cases, if it is entered into the agreement, will go to Singapore, because Singapore has a BIT. If you route your investment through Singapore and then invest in a company in India, you are safer, because then you get covered by the CEPS, Comprehensive Economic Partnership Agreement, CEPA, which we have at Singapore, which includes the BIT.
And the last point in this is that we have to bring in respect arbitration as the last resort for dispute resolution and not the Supreme Court.
Yes.
Because it's a technical subject of a commercial transaction. As long as that mindset doesn't come, we are not going to get arbitration as the arm in our hand to solve problems.
Absolutely. I'm afraid Mansi's already rung the bell for us. He doesn't want to ask us to ask any more questions, answer any more questions. We are running a tight ship. If you are interested in a more exhaustive discussion on the 28th of this month, I'm taking a 2-hour lecture on the same subject, where I'll be able to give more case studies and talk a little more about nuances of what has happened of the entire judicial system in India. But for the timing, thank you for being here. We log out now and we log in once again at 5 p.m. sharp, when we have the Consul General and other 2 panelists participating. Dr. Basu will be there to introduce our panelists. Dr. Basu, I'll have to try once again.
Thank you. Thanks for the audience to listen to us for such a long time.
And thanks to Narsi Monji.
And thanks to my own institute. And let me hope that these points which we talked about, gets passed on from one mouth to the other, and we develop a different mindset.
Thank you, sir.
Thank you.
Thank you.